Hi, everyone. I'm Ruth George, and today I'm joined by Leanna Pilarski. Hi, Leanna.
Hi, Ruth.
All right, tell everybody, Leanna, what do you do?
I practice pretty much solely in real estate, mostly residential, a little bit of commercial.
Right. So, real estate is so important, and you see a lot of different things in real estate as far as what people may not realize. And I'm bringing that up for a reason because one of the areas that you do see is when people are selling real estate that they may have thought had a totally different plan for. And that's called the life estate deed, where parents typically have transferred their home, their property to children and retained a life estate. And so often this seems so easy to do. And when I have clients, I get into great depth about all of the various factors that can come into play because otherwise people don't realize the pitfalls, the risks, and the problems that could happen into the future. And you, as the real estate attorney, have been a part of transactions where you're selling real estate that was a part of this planning. And so it's so wonderful that you can help us see, even at the selling closing end, what is going on. So, why don't you take us wherever you want to take us, either from the beginning, kind of the planning, or at the end where you're at the closing table and kind of some of the thoughts and things that you see with this planning so that people can become more aware, because that is really the goal, is to just make people more aware of this type of planning that has a lot of risks to it.
So I think ideally when people do this, um, their plan is usually the parent, the life tenant, can live in the property for the rest of their life, but the children that are called the remainder men technically own the property. And in a perfect world, the life tenant lives in the property until they pass away, and this avoids them having to go through probate with the property. And if the life tenant needed to go to a skilled nursing facility, it removes the house as an asset that can be taken for Medicaid purposes.
And can I just ask you one thing? Because
Mhm.
I know you've seen this as well. When real estate is owned by siblings, is it always the easiest thing for siblings to make decisions together with
No,
that
and
property?
everyone has to agree. If it's going to be sold while the life tenant's alive, the life tenant and all the remainder men have to agree. Everyone has to sign everything.
Right, but even if it goes to the point where the life tenant has passed and now we have siblings able to do what they want, it doesn't mean it's
Correct.
easy goings from then on, because siblings disagree. We have to
Yes.
worry even at that point who's picking up the tab on utilities, homeowners insurance,
Yes.
property taxes, maintenance, repairs. And then if we're going to sell it, who's going to sell it? Are we using a realtor? Are we not using a realtor? How much are we selling it for? So people forget, even just with that little item, that it is not the best planning. But I'm skipping to that point, and I know you have so many others to make. So keep going as far as telling us some more information about this.
Well, I think that the biggest issues that I see come up are because of things that you can't plan for. You can't see into the future. I recently had a sale contract. The life tenant is still alive, but needs to go to assisted living. He just can't live in the home by himself anymore. When the house is sold and the life tenant is still alive, there's a calculation that you have to use to figure out how much of the sale proceeds go to the life tenant and how much go to the remainder men. So I think that the sellers assumed that all of the money could go to the life tenant and he could use that to pay for assisted living. And they were upset to find out that there's an IRS table that you have to use that's based on current interest rates, based on the life tenant's age and life expectancy. And using that, the life tenant is getting maybe $16,000, which isn't going to get him very far in
Right.
assisted living rent. Um,
And it's a shock, right?
yes.
I think that's the whole point of the issues that we know we see, that people didn't see this coming, didn't even have it in their understanding because they just entered into this kind of deed quickly.
It sounds like a
So
great idea at the time.
right, right. And I want to hear more of your stories, but I just also want to state, even in that situation where you have the parent and the child who now have willingly decided to sell the property, you could have a situation where the children will not sell the property. You could have one child who holds out and says, nope, I will not sign a contract or I'm not agreeing to this. And as you were saying before, when you do want to sell the property during the life tenant's life, then we need the life tenant to sell, to sign the contract, and we need the remainderman to sign the contract. You could have parties who either don't want to or are incapacitated and can't. And it brings out just another point that this planning doesn't encompass the risks involved moving forward. But please continue on because I love all of your real life experiences with this. I think it's so helpful.
Well, that what you just said brought up a good point. A reason that one of the remaindermen might not want to sell during the life tenant's lifetime is something that a lot of times remaindermen also don't realize. They have to pay capital gains tax on their share of the proceeds, which again is determined by this IRS actuarial table calculation. So they're gonna, of course, they would choose to take a lot less and be taxed on less, but it's not their choice. And I've also had people very upset finding that out
Right.
when
And I
it's
know
too late,
we've
they've already signed a contract.
yes, we've talked about this where because you know, when this contract comes in and you're looking at things and you're seeing the current deed, you understand the situation as far as we've got a life tenant and remainderment. And I know because we've talked, you are advising them even at that point what it's going to look like in regard to the sale and the closing and the closing proceeds and how they will be split and what that will mean for each person's individual tax returns. And we are talking a lot of potential taxes now that have to be paid by parties because, again, this wasn't thought about at the time of doing this kind of quick deed. Tell us just a little bit more about that aspect of it because I think there's two ways you can talk about it. One is again, why people might want to sell. There are reasons why, even if they're not going to assisted living or nursing facility, the burden of owning that home becomes too great. And then also at that time of sale and dealing with the parties and the kind of shock that you've seen people have as far as realizing capital gains being an issue now.
I think the biggest reason that people would decide to sell, actually, I think the only reason that I've personally seen is the life tenants maybe live longer than anyone expected, and they can't live in the home alone anymore, and they can't keep up with the maintenance of the home anymore. So it makes sense at that point to sell the property. And as my one example had, they were hoping to use the sale proceeds to pay for assisted living, which is incredibly expensive. Um, but in another thing with capital gains tax, if one of the remaindermen doesn't live in New York State, there's additional income tax that has to be paid right at closing, which is also often a shock to sellers.
Yes. And you are the one who's seen this over and over and really bring this great experience to the table to help people understand that this kind of planning is more than just real estate. It incorporates estate planning and it incorporates the what ifs into the future. And speaking of those what ifs, let's talk a little bit about, because I know we've already talked about this amongst ourselves, a little bit about what if a life tenant or a remainderman has other issues, financial issues, creditor issues, bankruptcy issues. What if a remainderman passes? Tell us a little bit about that type of concern.
Yes, that's another thing that you just can't really foresee until it happens. So a remainderman owns the property. So any judgments, any bankruptcies, any financial issues that the remainderman has are going to be a lien on that property. So when the property is sold, those liens need to be paid off. Or, in bankruptcy, that's an entirely other monster that could affect the property. But if it was judgments and tax warrants that need to be paid off from the sale proceeds, that's even less that goes to the life tenant if the life
Right.
tenant needs the money for something.
Right. And again, we were talking before and talking about how the grantor, the parent, the person who has a life tenant can retain a special power of appointment. You can talk to us a bit about that, but then also why that also cannot be the everything you want it to be because of how situations unfold.
So that, and I've never um, had this situation, but with a special power of appointment, that's something that you have to think about in the beginning when the life estate deed is first done. And by including that in the deed, that allows the life tenant to change the remainderment without affecting the Medicaid look back period. But you again need a crystal ball because if one of the remainder men gets into financial trouble and starts having judgments and liens placed on the property, you exercise a special power of appointment and change the remainder men. At that point, it's too late. You have to do it before any of the liens attached to the property. Um, oh, and another thing, and I think you probably know more about this than I do, but the 5-year Medicaid look back period, that would also there's things to take into consideration selling the property during the life tenant's lifetime
Right.
that would affect that.
Right. So when we go to the issue of judgments, tax warrants, liens against the property, those items, once they are on title, as a real estate attorney, they will affect title. And you cannot just sweep them under the rug and pretend they don't exist. They have to be dealt with in regard to a sale and the sale proceeds being used to pay them off. And even if the deed reserved what's called a special power of appointment, so the grantor can potentially change remaindermen, we can't do that. We can't exercise that power of appointment to defraud creditors. So we often don't see that even working, right? Well,
Right.
that's why it's not really maybe used. And then another point is that if a remainder man passes, well, now we've got their estate to deal with.
Yeah.
And I know you and I have both seen that where you think it's just maybe one person entitled, but now you realize, oh my goodness, no, we've got this estate that owns half of it. That estate could include minor children. It could include judgments, other issues, creditors, things like that. It has a probate or whatever it has to go through. It totally blows up the situation and
What you were trying
causes
to do in
incredible
avoiding
grief.
probate.
So there was another, oh, the Medicaid look back, right? So of course, you've done this planning, hoping sometimes to tuck away the property in a nutshell that doesn't have to be then opened up in the sense that if you were to need this kind of care in a skilled nursing facility, you don't want to have to sell the property so that the proceeds go to the facility or something like that. Well, if you sell the real estate while you are in a facility or close to needing that type of care, as the life tenant, you must receive sale proceeds. You can't just say, well, I don't want them. I can't have them now. They're actually going to cause me an issue. You must take those proceeds. And then if you are in a situation where it's actually not beneficial to have those proceeds, they could end up going right to the nursing home, which is what you tried to avoid in the first place, right? And or just cause you more grief in that way. The other point of this is that sometimes with the planning that you think is going to be so protective, you end up just back to square one. It really is like a full circle. You didn't really accomplish what you want because you didn't have the understanding that you needed to in the beginning. And that's when things need to be done. Not once the deed is on record, you have to deal with that. It is not something that you can just say, well, I want to go to the trust now. You potentially could have all parties come back to the table and do something different, but that's not what people do. They kind of put that deed on record and forget about it, and that's that. Tell us another experience that you recently had as far as just dealing with this type of an issue, especially when it comes time to talk to the parties about what is going to happen and kind of the shock again that they can go through.
Well, I think the biggest, and I've said this before, but because I've seen it multiple times, is when the contract comes in and I first speak to my clients, the sellers, and I tell them I recommend that they speak to a tax professional because that's not my strong point, because they're going to have capital gains tax, and this is the way that the sale proceeds are going to be allocated, and they had no idea that that's the way that it was going to work out. At this point, they're already selling the house. They've already entered into a contract with the buyer. They're bound by this contract, and for whatever reason they decided to sell the property, they need to sell the property at
Yeah,
that point. So
yeah,
I remember my grandparents deeded their property to my mom and aunt and uncle years and years ago, I think before I was even in law school. And I remember it seemed like such a no-brainer. If they ended up in a nursing home, they wouldn't have to worry about it. They would none of their property, they wouldn't have to go through probate with anything because the house would automatically be owned by their children, and um they didn't have that many other assets. So it seemed like such an easy thing. And in their situation, they had the ideal situation. No one needed nursing home, and they lived in the house almost until pretty much until they passed. So they didn't have any of those issues come up. But I don't know if it was when did you see this like years and years ago? Everyone was doing it because it seemed like such a no-brainer for planning purposes, and it was so easy.
I think that people put on their rosy-eyed glasses and do the least amount of work, if at all possible. Now, of course, that's nice to be positive and that's nice to do the least amount of work. But when it comes to an asset that most people would consider one of the greatest of all assets that they own for various reasons, it is not a time to be this rosy eyed and let's not do any work, because that's not how you plan for something that means so much, that you put so much into, that has all of this equity. And it is not something to be taken lightly. And what I think is happening is that people hear things, and yes, maybe something works out for somebody, but it doesn't mean that's how you should think of your
Right.
situation. I don't know what the percentages would be, but maybe sometimes it works, maybe other times it doesn't. And the risk, considering the gravity of the situation, is it's so heavy that you really need to take the time to know what the pros and the cons are. And we've just touched on things here. I mean, this
Yes.
takes a full discussion, and we've kind of, just glanced at things and kind of swept through a lot, but there's so much more that you would want to talk to in regard to the pros and the cons and what it looks like, not just for your particular situation now, but into the future and all of the unknowns. So I just get a bit irritated, I think, when people just say it like it's, yeah, yeah, you buy a sandwich. It's just the thing to do. It's like, no, we've got a little bit more to think about here. This is not just buying a sandwich and I'll order this. And it's the same for everybody's going to work for everything, and no matter what happens in life. Estate planning has to encompass the risks, because if you don't, then you are setting yourself up for potential failure. And I think even the point of having remaindermen not be able to come to an agreement on what should happen,
Yeah.
even that alone is such a scary thing when I see people fight, not be able to agree who's paying the property taxes until this is sold, who's paying the homeowner's insurance, who's doing the repair and upkeep. How come I'm going to the house all this time and you're not doing anything? What if one of them passes then? And now we have one of the children owning it with the estate of the other, and then minor children involved. I mean, I kind of just keep going on and on because to me, I see this day in and day out, and I know you do as well as far as the real estate end. So I could go on about all of this. I think the whole point of this video is just for people to understand there's more than meets the eye when it comes to this, and to don't just do something quick and simple. It's
Because
not
you heard
the
of a
kind of
family
planning.
friend that did it.
Say that again.
Because you heard a family friend that
Yeah,
did it. And
yeah, yeah. It's one of those, let's not just all look to somebody and say it worked for them, it's going to work for me. It has to be, all right, let's really put on our thinking hats here and think about what's going to be best for your situation, and then also think about the pros and the cons. And
yeah,
of course, we have trust planning involved. You can have a qualifying trust that qualifies for all sorts of tax planning purposes, Medicaid planning purposes, creditor planning purposes, avoiding probate, management of the property itself. So there's so much that can be done. Leave it on a positive note. So planning opportunities do exist, and that's what you want to know about, that there's an option that can be very beneficial.
yeah,
All
taking into
right.
consideration that you don't know what's going to happen. You don't know how long any of the parties are going to live, and there's tax consequences, and all of that should be taken into consideration from the start.
Yeah. Well, anything else that you wanted to add since we've been having such a fabulous discussion?
So,
I know we talk all the time. So we're always chatting with each other about, did you,
crazy
see the
issues.
situation, or can you believe this happened, or whatever. So we kind of know a lot between between ourselves of what we're talking about, what's going on. And it's kind of hard to get it all out there. But the whole point of it is there is a lot there, right?
Yes.
Yeah. And so thanks so much for helping the audience understand that, and understand that this isn't something to just decide quickly about.
Yes,
Yeah.
very basic reasons for that.
Yeah. All right. Well, thank you so much, Leanna.
Thank you so much.
I have to end this with saying this video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship. And I look forward to seeing you on another video.